Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on today's docket is Davis versus the state of Florida. Counsel?
May it please the court. Steve Gosney representing Jahquell Davis. And we have an interesting case here that obviously I represent Mr. Davis here, and we're here on a speedy trial. What defines arrest for the purposes of speedy trial? And Judge Orfinger very wisely
Can we start in a different place? Maybe, what's the purpose of the procedural speedy trial rule?
What's the purpose of the
Yes.
procedural? Well, I think it is to protect and to validate the federal and state constitutional rights of the citizen and the individual to speedy trial. And I think it's enunciated very well in some of the cases I cited from the U.S. Supreme Court. I mean, this is a fundamental constitutional right. So how that is implemented is obviously complicated, it's very procedural. So the procedural rules and the case law is meant to lay out an adequate protection for the citizens to be free from unnecessary detention and arrest
And
after arrest.
what act implicates the Sixth Amendment constitutional speedy trial right?
Well, that's exactly what the legislature's
No,
decided.
I mean, if you just don't look at procedural rules, but
Right.
ask what act under, there are plenty of precedents from the U.S. Supreme Court that talk about the act that starts or implicates the speedy trial right itself. What act would that be?
Right, and I think that would be the act of arrest.
And that would be a formal arrest, correct?
Well, in Florida, we've defined
No,
that.
I'm talking about the constitutional right that this procedural rule is trying to implement. What act starts the constitutional protection?
It's the act of arrest.
And it's formal arrest, right?
No, I think it's also de facto arrest. Formal arrest definitely, and we agree on that formal arrest definitely triggers speedy trial. But then you also have this issue
the
about...
speedy trial right attaches, according to the U.S. Supreme Court, when someone is held against charges. In other words, when they're released on bond or released on their own recognizance, but after an information is filed or after an arrest that results in charges and release on conditions. That's the speedy trial right. That's what it protects, correct?
Well, I think that, I don't know if I would go that far. I think that the U.S. Supreme Court has defined the constitutional speedy trial right is triggered by an arrest. That is true. I don't think that they've gotten to the point where they've said it must be a formal booking arrest. In fact,
that's the test that they use for their procedural rule, isn't it?
Well,
what is a formal? The definition of a formal arrest? Is it the officer using the magic words, "You're your guy under arrest"?
Well,
or is it the actual booking, the picture taking, the number, and the whole thing?
well, we agree, I think, with the state that formal arrest triggers speedy trial. The question
What is a formal arrest?
Formal arrest would be the picture taking and the fingerprinting and the formal, that would be formal arrest. You could also say indictment. I think that there's a two-prong, there's also indictment. But here we're talking about the definition of what is an arrest for purposes of speedy trial. And the Florida has stated that in custody, putting somebody in custody is also triggers speedy trial. That is an arrest in Florida law.
But isn't there a difference between an arrest and custody? A detained custody, which is not necessarily an arrest, where you're having a custodial interrogation that would require Miranda, but is not a formal arrest?
Well, there are exceptions. For instance, a Terry stop. A Terry stop is a detention that is justified constitutionally as a reasonable measure police may be taking to protect themselves from physical harm, from having weapons. Similarly, an investigatory stop. You might have a crowd scene, you want to stop people and identify them, make sure that you know who these people are. So there's a minimal, a police requirement. But we have to err on the side of the liberty of the citizen. And then when the state acts in contravention of liberty interest, that there needs to be something additional. So the question is de facto arrest. I think that's where the rubber hits the road here.
Why would we have and I'm fast forwarding a little bit here
Sure.
because I know we're starting at some basic principles, but why would we have the same definition for what are ultimately different terms used in our Constitution? So the Fourth Amendment, as I understand it, uses the term seizure, correct?
Yes.
Okay, that's very different than an arrest, right?
Well,
It's not the same word.
Well, this is one of those, how we define words. I think it's very important, and I think I pointed this out in the brief, that the perspective on do we err on the side of police power and state power, or do we err on the side of individual liberty?
Well, I understand that that's very lofty, and I understand that, but I guess my question is, why would I define arrest the same way that I would define a very different word used in the Constitution, which is seizure?
Are you talking about the Popple analysis, as in, when Miranda is triggered for
What I'm
arrest
talking
purposes?
about is you advocate, and the Fifth DCA dances around, that maybe we should read this all the same way.
Right.
And I can see the ease of that. Certainly it's easy if you just read different words the same way, but they are different words. Why would we read them the same way? And I'm just talking about the Fourth, and whether you use Popple or anything else, the Fourth Amendment, the same way we would use the concept of arrest for speedy trial purposes.
Well, because they're both defined by the Constitution. They're both fundamental rights defined in the Bill of
Agreed,
Rights.
but there's different words used in the Constitution to describe those rights.
Well, I mean, the Constitution has different words for different things. I mean, I think
Right,
the
and-
arrest, though, should remain consistent.
And
First
don't we read those words differently because there are different words used?
I think that's playing word games to basically eviscerate the individual liberty of a citizen and the right to speedy trial by playing this game that Melton plays and creating kind of these subjective standards.
But do you not agree that, for example, there are cases where there could be a seizure under a Fourth Amendment case, but that seizure, which would necessarily require a Miranda warning, wouldn't necessarily implicate a speedy trial?
Right. Actually, I've been thinking a lot about this since I wrote my initial brief, and about which side would I push? Would I push Popple, or would I push the and I think that, of course, the wisdom of Judge Orfinger below is that the reasonable person standard that is put forward by this court in Voorhees and is probably the right way to go, and that
So your analysis is objective versus subjective. Your
Absolutely.
position is that Melton is a subjective test as opposed to an objective test.
especially the first element. I mean, I'm sort of a trial guy.
Well, let me ask you a question. If your position is that it should not be based on what the police officer intends. If the police officer has not done a formal arrest, but you're detained and you're under a custodial interrogation and Miranda is implicated, but then you're free to go. You can now walk out the door. And there's no formal arrest. But the person would perhaps believe that they were under arrest because they were not free to leave. Your position is at that point, speedy trial would be implicated.
Well, it depends, I think, on the reasonable person standard as enunciated in Voorhees. It is incumbent upon the police to not cross the line into individual liberty unless they have probable cause and the protections. Arrest triggers constitutional protections. And this is, for people to say, well, I'm going to put you in handcuffs, throw you in a car, put you in a room, put a light in your face and question you, and then for however long.
But
and then say,
the
well, I didn't formally
the
arrest you.
individual could have also said, when he was placed in the vehicle, and I understand in this case he voluntarily did not go to the police station, but once he got to the police station and they read him his Miranda rights, he waived his Miranda rights, and then he agreed, he acquiesced to interrogation. He could have said, no, I choose not to speak to you and I would like a lawyer.
Well, there is a case, and the law is that believe that you can't voluntarily, once your speedy trial rights, you can't submit, if I find that case, that's a separate issue as to my particular client in this case. We're talking about a big issue here for practitioners, and that is, how do we define arrest and when somebody placed under arrest? It's incumbent of the police work all the time. They're under the reasonable person standard. This is very well.
Let me get back to, I'm just, so any detention implicates a constitutional right. Any detention by a governmental agent
Sure.
implicates a constitutional right, but not the speedy trial right. So this is not the unreasonable detention rule of procedure. This is a speedy trial rule. Wouldn't you agree that the speedy trial right should be timed to start when the Sixth Amendment right is implicated, since this is a procedural rule that's designed to implement the Sixth Amendment protection?
I'm not sure.
I mean, we could start it on any detention. This could be the unreasonable detention rule. So
It could, but Florida defines it as in custody.
I'm talking about, we're talking about basic level first principles. This rule is designed to protect procedural rule, the speedy trial right. And we're talking about when the time starts to run. Does it make sense to start it with any detention?
Well, no. In fact,
No.
any detention, I mean, there's
But
Terry.
that's a
there's-
right. That's a right that's protected by the Constitution. You have a right not to be unreasonably detained. Maybe it's any unreasonable detention. Would that work?
Well, I think the standard is right there. I mean, the reasonable person standard is applied in other contexts, is right there, and
But do you agree or disagree that it ought to start, the speedy trial rule ought to start running when the speedy trial right itself is implicated and not some other constitutional right?
I don't think so. I think that we have liberty interests. We have a right to be free from unnecessary interference. And once the police take you into custody without justification, we're talking about, not police safety as in Terry and not Miranda, which is
So if
Popple.
someone is detained for an unreasonably long time at a traffic stop so that dogs can be called to search for drugs and drugs are found, what happens?
Well, I think
If
you would
they're
apply the
unreasonably-
reasonable person standard.
No,
and
if they're unreasonably, so I'm talking about the right not to be
Unreasonably.
seized, the unreasonable detention. If someone is detained unreasonably, longer than it takes to conduct a traffic stop, and then the search is found, in a search, cocaine is found, what happens to those drugs?
Well, I mean, the state would have to bring charges within the 175 days, which is not unreasonable. I mean,
Wouldn't that be suppressed as a violation of the Fourth Amendment right?
well, that's.
I mean, there are other protections that deal with other constitutional provisions.
And that's where I come back to. Why would we read? You seem to want to conflate the Fourth, Fifth, and Sixth Amendment right all together. And what I'm having trouble understanding is where the Fourth Amendment uses the word seize or seizure, and where the Fifth Amendment is understood to mean custodial, as in custodial interrogation. Why would we use a different word, arrest, to mean those very same things when those provisions deal with very, very different subject matters?
And that's why I talked about the approach, because do we err on the side of individual liberty in which the Constitution defines our rights and we need to protect the rights, and then...
Well, isn't the approach to define those as they're specifically used in the amendments themselves?
But to have an ever-shifting definition to fit particular right into this, depending on
It's not a different
circumstance.
definition, it's a different word, right? If I use the word green, it means something different than the word blue, doesn't it?
Yes, but the arrest word is the same in either of those contexts. This is triggered by arrest, and this is triggered by arrest, and then we're saying we're going to change the definition of arrest?
But that's clearly not true, because you agree that if it's below de facto arrest, it's not triggered. So if I
Right.
seized, my Fourth Amendment is triggered, but not necessarily my Fifth, because if no questions are asked, and my Sixth, if there's been no arrest, correct? You would agree with that?
I don't know if I followed that. I'm not sure if could you say?
Sure. Let's take the Terry stop situation.
Sure.
That implicates the Fourth Amendment,
Right.
but if no questions are asked, meaning it's just a pat down of some sort, that doesn't implicate the Fifth, right?
Right,
And that doesn't implicate the speedy trial right, correct?
that's correct.
Okay, but yet there is a seizure.
But then we're talking about a balance between, there's a balance of interest there. Terry is involved in police protection. There's a legitimate state interest.
I know,
being-
but the reason it triggers there because it's a different word, a seizure. A seizure happens before a custody necessarily, or not necessarily, but sometimes, and also before an arrest, right?
Well, there is a balancing of interest in all these constitutional rights. They work together, and I think we need to look at legitimate police investigatory reasons and balance that with liberty interests. I just don't see how we can change the word depending on context and say, well, we're going to play the game with this, when I think Melton is is a 54 case we're talking about 60 years ago, and there's been the model penal code, there's been common law pleadings been changed. So many things have changed since this definition.
I don't know that Melton is the best way to define it. I'm just having trouble getting to where you want us to go,
Sure.
where you're telling us that the same definition for the Fourth Amendment and the same for the Fifth Amendment should apply in the speedy trial context.
Okay, well, I'm way over my time, but I would like to reserve and whatever I have left. But thank you for questions.
Thank you.
May it please the court, my name is Chris Davenport, and I represent the state in this matter. The Melton test has been around for a long time. It's been used in a lot of cases. It is not without its deficiencies, and I think that's illustrated in the Griggs case, where the guy came in. He was clearly arrested under Melton. He was told he was under arrest. They intended to hold on to him, but they said, but we'll let you go if you do a substantial assistance agreement. He said, of course I'll do that. He was let go. And the court still found, well, under Melton, he was under arrest. But he wasn't ever formally arrested, but he met all those factors. He was told he was under arrest. He believed he was under arrest. There was an intent to arrest unless he did this cooperative thing.
What does the word arrest mean when it was used when first put into the rule into 3191 sub D?
Well, this court has said that arrest means you meet the Melton factors.
Well, I know what we've said. I know we've applied Melton in that
Right.
context, but I guess I'm asking is, what does it mean?
According to precedent, that's, been
put
around a
precedent
long
aside
time.
for
It
the
means it
moment.
meets these factors.
What
What
is an-
does it mean
what
under
is an
the
arrest?
Constitutional?
In
On the
19 whatever, when we enacted 3.191D, what did arrest mean? Because Melton is not a speedy trial case.
It's not a speedy trial case.
Melton is a
It's
search
Fourth
incident to
Amendment
arrest.
case, yeah.
It's a search incident to arrest case, which that
Yes.
law has been completely changed since then.
Yes, it has. But that's the test we've always used. Is it the right test? We would submit you should apply the federal rule. It has all the objectivity that the 50 CA was concerned about with Melton, and it avoids situations where a person is told they're under arrest, but it never actually happens.
Well, that
Like in Greg's.
that may make a lot of sense if we were to write a rule prospectively, but we also have a case before us that was
Right.
applying a rule that applied at the time. And so I guess my
Right.
question is, if Melton is not right because it's from A, before the rule was even written, and B, was in a context that had nothing to do with the speedy trial right,
Right.
what is the proper way we should read the rule as it is currently written? Not as we all would want it to be, but as it is currently written.
We would submit you should read the rule as it's read that to mean arrest means a formal arrest. In other words, you're booked, you get the number, you're let out on bond, or you're held.
Except that we know, because I think you've cited Griggs and some others, where there is the concept of a de facto arrest. In other words, you're held long enough without charges such that it turns into an arrest.
Yes, there is that concept on using, because they're applying the Melton test. Is that the way the court wants to go under the speedy trial rule? Well, we would submit, it doesn't come up a lot because Melton's a hard test. They have to meet all four factors. In general, the test works, but it doesn't always work. In cases like this, it's subject to question, although I think they clearly did meet the factors here. And in cases like Griggs, where the person was told you were under arrest, the officer said, I intended to arrest him. They met all of those factors. They let him go. They reached an agreement instead. Under the Constitution, he wasn't arrested. Under the federal law, he wasn't arrested. The court found, applying the Melton test, that he was arrested because that's the test we've always been told to apply in this context. Now, the 50 CA has said we should ask this court to decide whether or not we should continue to apply that test. We would submit that their test is much, much worse. It's completely unmoored from the Sixth Amendment interests.
Can I ask you a question regarding the Sixth Amendment? I mean, the Sixth Amendment and Florida's version of the Sixth Amendment in Article 1, Section 16, the speedy trial of Sixth Amendment, the language specifically says, in all criminal prosecutions, the accused shall enjoy the right to a speedy trial.
Right.
By the plain language of that text, does it not mean that you have to have a criminal prosecution commence in order for the right to begin?
Yes. By the plain language of that rule, it means you have to have a criminal prosecution. So when they're brought in like this guy was, they check him out, they let him go, there's no criminal prosecution
Well, a
against
criminal
him.
prosecution would begin with a formal arrest or an indictment or an
Right.
information.
Exactly. So applying just the plain language of the rule, and just the plain language of the Constitution that the rule is designed to protect, yes, it should be a formal arrest. That's why we propose that test. Melton's been around a long time. Again, it works most of the time, but we would submit, if you're going to look at just the language of the Constitution, that Melton is a Fourth Amendment case. It really has very little to do with speedy trial. It's just been around a long time. So there is some reliance on it. You know, you have the stare decisis issues that this court needs to decide whether or not they believe that there'd be disruption by getting rid of it. We
But
would
stare
submit-
decisis is its weakest in a constitutional context.
Correct, yes.
What do we do in a case where law enforcement, for whatever reason, decides to take someone in, put them in the county jail, but the prosecution never files any sort of information, never files any formal information or charges, and 5 days later opens the jail door and says, Mr. Arrestee, you're now free to go?
And they've booked him and everything?
I don't know, they actually took fingerprints. They took a
But-
guy off the street and put him in the county jail
And just were holding him?
and held him for 5 days, and then opened the door and let him go.
Well, there's no
Wouldn't that be handled
criminal...
at initial appearances?
Yeah, he'd get an initial appearance within 24
Well,
hours.
no, I know that's how it's supposed to work. What happens if it doesn't work that way?
If
Is
for
that
some reason he falls through the cracks and gets lost in a
right?
jail cell?
Because that's never happened before, that someone's never gotten, right.
Of course
Right.
not.
Not in Judge Lawson's courtroom, I assure you.
Absolutely
but
not.
In
If
Miami-Dade County, once or twice it's happened.
He has rights under the rules of criminal procedure. He gets that first appearance.
I understand
Within 30
that.
days, you have to file charges or you let him go.
But that's really not my question. My question is, that doesn't happen. He's there for 5
He's
days
just-
for whatever mistake.
He's just sitting, we fell
He's-
through the cracks.
He's let go, and then 2 years later, he's arrested on the same charges. Is that original custody and arrest?
No.
That's not a de facto arrest.
I would submit that we need to get rid of the concept of de facto arrest in this context.
That's a pretty extreme position that
Well, but
doesn't constitute a formal arrest where you were held without charge for 5 days and then brought back later on those same.
But he's just held. He wasn't arrested.
Right, he's
So-
in a
so-
jail
Formally
cell.
arrested as the test
So-
is, we
I just
propose
want to
a
be
black
clear.
and white test.
I just want to be clear. The Constitution cares about fingerprints. So that's being fingerprinted and taking a picture of is the distinction between someone's actually arrested or not.
The Constitution cares about whether or not you're formally arrested. This guy
Tell me what that
fell
means.
through the crack.
The
That
police actually has to tell you you are now under formal arrest?
means you're brought into the jail and you are formally arrested and you go through that process. That's what we would submit, would be
Well,
the
then
easiest black and white
can't
objective.
you just have anyone, I mean, then you can have law enforcement decide, well, we're just going to hold this person and not formally arrest him, and maybe he'll break and start talking.
Well,
It sounds a little bit like a police state.
well, you do have other constitutional protections in that context, because if you're held in a jail cell and we're going to wait for you to break, the Fifth Amendment applies. Nothing that they get out of him is going to be introduced
Well,
at trial.
assuming that they let him speak to a lawyer, I guess, if they give him his Miranda warnings. I mean, but the implication is that the law enforcement could do whatever it chooses to do, and constitutionally, I don't see how that's feasible.
Well, if they were unlawfully detained, you'd have Fourth Amendment and Fifth Amendment protections, so nothing they got from him would work. Could they do it anyways just to be jerks? Sure.
Just
But it
because
doesn't.
you have other constitutional protections doesn't mean you have to give up another one that you have.
Well, but you're not giving up anything. The question is the speedy trial period running? And we would submit it's not, because there's no criminal prosecution against him. He's not formally arrested. He could file a habeas petition and get out. He could file a civil action for false imprisonment or a Section 1983 action. He's not without remedy. It's an
How would
unfortunate situation, but the question is it speedy trial?
Under federal law, how would the hypothetical given by Justice Luck be handled?
I would submit under federal law, the speedy trial wouldn't start running. And that's what we should follow. I mean, it makes the most sense. It's implementing the Sixth Amendment.
So in McDonald, the United States Supreme Court said that the The Sixth Amendment Speedy Trial Clause is designed to minimize the possibility of lengthy incarceration prior to trial, to reduce the lesser but nevertheless substantial impairment of liberty imposed on an accused while released on bail, or to shorten the disruption of life caused by arrest in the presence of unresolved criminal charges.
Right.
And because of that, they went on to explain that if a case is dismissed, no information is filed, that there is no Sixth Amendment issue at that point, even if the person was formally arrested.
Right.
Correct?
Correct. And that's not how it's been applied in Florida.
I know. But, so your position is that the procedural speedy trial rule should be interpreted in light of the right that it's trying to protect?
Absolutely.
Okay.
That's exactly
And
it.
to do that, or an arrest would be a formal arrest,
Yes.
and someone's either in jail or charges are, or released on their own recognizance or released on bond.
Exactly, because that's when that liberty interest is implicated.
Thank you.
If you get into they detained him for a long time, then you're going to have to start this gray area. Well, okay, they kept him in a cell for 5 days. That's pretty offensive to everybody. Well, this guy was held in a police station for 7 hours. That's offensive to some people, too. And you're going to have to start making these judgment calls. We submit it's a lot easier to just follow the federal rule. And it still protects that Sixth Amendment interest. There are other remedies. Not everything is a speedy trial violation just because we don't like what the police are doing. That's an unlawful seizure. It would be, improper custody unless you read Miranda and give him his rights in that situation. It still could be involuntary, even with Miranda. If they just sat him in jail and said, we're going to wait you out, that could still be a Fifth Amendment violation. It's not a speedy trial violation, just because we don't like what they're doing, is my point. So we would submit, Melton's been around a long time. If this court is not inclined to find that it should be overturned, we can work with it, but the better rule would be to follow the federal model. That's what this court should do. It certainly shouldn't do what the Fifth ECA has suggested, which is essentially using that Fifth Amendment test in this context. It just doesn't make any sense to apply that in this context. There's such different issues. If I may just quote from Justice White in Marion, there's no right to a speedy investigation of the charges of the crime. There's no constitutional right to that. That's not what the Sixth Amendment says. And as Justice White put it, the framers could hardly have selected less appropriate language if they had intended the speedy trial provision to protect against pre-accusation delay. So we agree with that. We would ask the court to adopt the federal model if it is inclined to eliminate Melton. Thank you.
Thank you.
Thank you, Your Honors. If I could, just Supreme Court of the United States, Dickey versus Florida, which is cited in the initial brief. Speedy trial right is an important safeguard to prevent undue and oppressive incarceration prior to trial, which we discussed. Speedy trial is intended to minimize anxiety, concern accompanying public accusation. So we observed lengthy prosecution may subject an accused to public scorn and deprive him of employment, and almost certainly will force curtailment of his speech, associations, etc. So it's more than just this.
But by the sentence that you just read that talked about public accusation, that implies that there already has a criminal prosecution has commenced, because you would only have a public accusation if there is actually something that has been filed.
But then it also says, accused may deprive him, force curtailment of his speech, associations, and participation in unpopular causes. So he has been detained, de facto detained, for an accusation for some crime. And now he's going to go forward knowing that that cloud exists over him, and that will curtail his liberty going forward while this cloud is over him. Now, if there's a speedy trial implicated, then the state needs to get on the stick and either charge or not charge within 175 days. Or
I'm having a hard time understanding how someone's liberty is in any way limited by a detainment that's too long, except during that detainment period. Once they're released,
because somebody is being detained for some reason theoretically. There's a crime that's being investigated, an accusation that's being
Right, but the
explored. So let's say
the
it's
person is brought in this case.
Mhm.
They agree to talk to the police, and so they do. As Justice Lagoa said, they could have said, no, I'm not going to talk. Am I under arrest, yes or no? And then they could have left, but they stayed and talked with police because I think your client said that he wanted to clear his name, so he wanted to do that. So after he was said, oh, the police said, you're free to go, how is that defendant's liberty in any way limited?
Well, and taking it from, let's assume that there's
How is the
some crime associated here.
Yes, so there was a crime, someone was questioned, they're told they're free to go, they are not formally arrested, how is their liberty limited?
Because the cloud of
Can they
suspicion...
leave the county?
Excuse me?
Can they leave the county?
Well, that's a question. I mean, what if, can they associate with the people that they've associated before? Are they under surveillance?
Has the government told them that they can't?
Well, having a government accusation over your head can impact somebody's behavior substantially. I mean, are you going to be associating with the same people you associated with? Are you going to go to the same places? You know, there's a having
You
that.
can have an accusation over your head from the government in all kinds of circumstances.
Sure.
Officer can come and say, I know you did it. I can't prove it, but we know you did it.
But they're doing
Our
more
eye
than...
is on you. That obviously doesn't trigger anything, does it?
No, clearly not, because they're not put under de facto arrest. And I want to jump onto the de facto arrest, because that's the
So it's
critical
not just, so the fact that there's the accusation that you're focusing on, that kind of informal accusation, that's really irrelevant for the speedy trial purposes, isn't it?
Well, when the police go to an extent of detaining you and placing you under arrest, then that accusation is becoming very real. When you're voluntarily helping out the police, that's a different situation. But now all of a sudden you're putting in custody and your liberty has been detained. Now the government is pointing the finger at you through that action, because they're saying there's something more here than just interacting with you as a citizen. I would also go back.
Right, but then other constitutional rights are implicated, i.e. the Fourth Amendment. So now you have a Miranda warning. That's why the Miranda warning is given, because it's custodial interrogation. But in this case, they did a custodial interrogation, Miranda was done, and then we spoke to you, and now you're free to go.
Well, and I'm not sure which justice stated it, but because you have other constitutional rights, that doesn't minimize the one that is given under speedy trial.
Right, but there's a reason why there's a fourth, a fifth, and a sixth. They don't all have the same rights, constitutional rights, correct?
Well, every right is different,
Correct.
but that doesn't mean definition of arrest changes depending on which right is being implicated. That's the point of what I'm saying. Is it the liberty interest of the citizen we're protecting, or the police and the state and overarching state power? I mean, there has to be a judicial check on state power. That's why a de facto arrest is important, for exactly the example that Justice Luck described, in that is, are we just going to let the police do whatever they want, or is there some definition of arrest that we're saying exists outside the context of simply the executive saying this is what we're going to do, and that's how we define it? That's not the way the system works. We have checks and balances. That's why I think the Voorhees case, which is when determining a particular encounter is consensual, must look to all the circumstances surrounding the encounter when deciding if the police conduct would have communicated to a reasonable person that the person was free to leave and terminate the encounter.
Well,
That's Bostic.
how do you distinguish then the U.S. versus Marion case, which is a United States Supreme Court case that actually addresses the Sixth Amendment right that's implicated in the speedy trial?
I think you got me on that one. I'm not sure. I'd have to punt. But I will appreciate the court's, and just one more point, if I can sneak it in. Melton is not...
Your time's up, so
Okay.
I'll give you 30 seconds.
Oh, thank you, Your Honor. Melton, I put in footnote 9 of the initial brief. Melton is not heavily relied on by this court or anything. It's not any kind of precedent. And as Your Honor said, it's also not something that is... It's also constitutional, so this is the least deference given. And the fact that we've had so many changes in the model penal code, in all the civil rights era, this is old precedent that needs to be conformed with other definitions of arrest. Thank you, Your Honors.
Thank you.
We thank you both for your arguments.